Hi YouTube, Legal Doug here again. Let's take a look at another case in the area of constitutional law. Today we're going to take a look at Turner v. Driver. It's a 2017 case. It's actually out of the Fifth Circuit. It's not a U.S. Supreme Court case. But it's interesting, has a lot of applicability to First Amendment auditors, I think, and is an interesting case. Philip Turner, the plaintiff below, who lost below, and the appellant in this case, is a pretty well-known First Amendment auditor on YouTube. He goes by the name of Batosai, if I'm saying that right. And this case took place in Fort Worth, Texas. It's a case where he was filming a police station, I believe, and it was approached by some police officers. The defendants in the case were Lieutenant Driver, where the name Driver comes from in the case, Officer Grinalds, and Officer Dias, and they've all been sued in their individual capacity, and that's important because the main point of this case is qualified immunity. Now there are First Amendment filming your police in the course of their duties or otherwise issues involved here, and also what constitutes an arrest. Those are the main legal points that were looked at as it applied to qualified immunity. So again, this is in the Fifth Circuit. The Fifth Circuit consists of Texas, Louisiana, and Mississippi. This is Texas, and the judge below was John McBride. He in the Fort Worth Division of the Northern District of Texas Federal Court. He's a story unto himself. He had a reputation probably among some attorneys. He as I understand it, had held a couple in jail overnight for certain behaviors in his courtroom. And I believe at one point the Fifth Circuit took away his cases for a year. So he had a reputation already going into this case, although plays a fairly minor role in what we're going to talk about. All he did was get to the dismissal of the case on qualified immunity pretty early on. And then everything goes from there. Just as a side note, I've had a couple of cases in Judge McBride's court. Really, in federal court, you don't go down to the courthouse very often, unlike state court, where every other day you're arguing a motion. Federal court, the judges basically rely on the briefs. So I didn't have a lot of face-to-face interactions with Judge McBride. But just knowing his reputation, I was as careful, certainly, as I could be in his court. But so, having said that, I'm going to skip over the attorneys in the case. This case was decided before Judges Weiner, Clement, and Higginson. And that's the way the circuit courts work. I think last I looked, there were 26 judges in the Fifth Circuit. But they create panels, for periods of time, and 3 judge panels to decide all the individual cases. That if they had to have every case in front of 26 judges, they'd never get anything done. If something is particularly contentious, I think it can go back up before the entire court en banc for a decision made at that level. But this is one that was before a 3-judge panel. Just again, to give some context to everything, Judge Weiner was appointed by George H.W. Bush in 1989. Judge Clement was appointed by George H.W. Bush also in 1990. And this is the part that confuses me a little bit. Judge Higginson was appointed by Barack Obama in 2011, I believe, to replace Judge Weiner. So I'm not sure exactly how Judge Weiner is on this panel. Maybe as some kind of traveling judge role with the circuit court. If anybody knows, please feel free to post a comment below to shed a little light on that. But let's go ahead and take a look at Judge Weiner's opinion. I'm going to read through a lot of it. I won't read through all of it. Starting off, we've got plaintiff appellant Philip Turner was video recording a Fort Worth police station from a public sidewalk across the street when defendants, appellees, officers Grinalds and Dias approached him and asked him for identification. Turner refused to identify himself, and the officers ultimately handcuffed him, important, and placed him in the back of a patrol car, also important. And the fact that he refused to identify himself also important. A lot of YouTube auditors talk about in Texas, they describe the rule as basically the national, Fourth Amendment rule. The police have to have a reasonable suspicion, articulable suspicion that crime is afoot. Basically, language right out of Terry v. Ohio. I don't know how to do that. I'll post it right here thing, but I'll post it right here. I've got a video on Terry v. Ohio. And so the officer, supervisor, defendant, appellee, lieutenant driver arrived on scene, and after driver checked with Grinalds and Dias and talked with Turner, the officers released Turner. They go on to say each officer filed a motion to dismiss when Turner sued all of them below in Judge McBride's court, and insisting that each officer insisted that he was entitled to qualified immunity. Again, that's the key, very key to this case on Turner's claims. The district court granted the officers' motions, including that they were entitled to qualified immunity on all of Turner's claims against them. Judge McBride is the district court. He dismissed Turner's claims based on qualified immunity, and then that's what Turner is appealing. And the three-judge panel from the Fifth Circuit says we affirm in part and reverse and remand in part. And remand just means that the reversal has changed the situation where the court below now needs to make some other analysis. So the case is getting sent back down to Judge McBride's court. I will say also, Judge McBride passed in 2022 at the age of 91 while still on the bench in the Northern District of Texas Federal Court. So next section, I'm going to go ahead and read. The facts are not that long. I'll go ahead and read all of them. In September 2015, Turner videotaped the Fort Worth police station from a public sidewalk across the street from the station, as we said above. He was unarmed. While videotaping, Turner observed Fort Worth police officers, Grinalds and Dias, pull up in a patrol car in front of the station, get out, and approach him. Grinalds asked Turner, "How's it going, man? Got your ID with you?" Turner continued videotaping, and Grinalds repeatedly asked Turner if he had any identification. Let me finish the thought on the Texas rule. All 50 states, people are entitled to Fourth Amendment protections from illegal search and seizure, and demanding ID falls under that. In Texas, the rule is actually under Penal Code 3802. You have to actually be under lawful arrest already for failure to identify to be a crime. So Turner asked the officers whether he was being detained, and Grinalds responded that Turner was being detained for investigation and that the officers were concerned about who was walking around with a video camera. Turner asked for which crime he was being detained, and Grinalds replied, "I didn't say you committed a crime." Again, understanding the Texas rule, that's important. Grinalds elaborated, "We have the right and authority to know who's walking around our facilities." Grinalds again asked for Turner's identification, and Turner asked Grinalds, "What happens if I don't ID myself?" Grinalds replied, "We'll cross that bridge when we come to it." Grinalds continued to request Turner's identification, which Turner refused to provide. Grinalds and Dias then suddenly and without warning handcuffed Turner and took his video camera from him, and Grinalds said, "This is what happens when you don't ID yourself." Turner requested to see a supervisor. Grinalds continued to ask for Turner's ID and told him that he would be fingerprinted so the officers could learn his identity. The officers placed the handcuffed Turner in the back of their patrol car and left him there to sweat for a while with the windows rolled up. Turner alleges that no air was getting to the back seat and that he banged on the door so the officers would roll down the windows. Lieutenant Driver approached Grinalds and Dias, and they seemingly ignored Mr. Turner. The three officers then rolled down the window of the patrol car and found Turner lying down in the back seat. Lieutenant Driver identified himself as the commander. Driver asked Turner what he was doing, and Turner explained that he was taking pictures from the sidewalk across the street. Driver asked Turner for his ID, and Turner told the lieutenant that he did not have to identify himself because he had not been lawfully arrested. That's the Texas rule. Turner had that part right. Arrested, and that he chose not to provide his identification. Driver responded, "You're right." Driver walked away and talked with the officers, then returned to the patrol car and talked with Turner. Turner said, "You guys need to let me go because I haven't done anything wrong." Driver again walked away from the car, talked on the phone, and spoke further with the officers. They returned to the car and took Turner out of the back seat. Driver lectured Turner, and the officers finally released him and returned his camera to him. So those are the facts of the case. That's what this is all about. Just for some of the but the court history here, we've got in October 2015, Turner filed suit in Northern District of Texas against Driver, Grinalds, and Dias, collectively defendants, in their individual capacities. Each officer filed a motion to dismiss under Rule 12b-6 of the Federal Rules of Civil Procedure. That's a rule that basically says failure to state a claim upon which relief can be granted. I call that the "yeah, so what" rule. I did it, but so what? You don't have an illegal claim. Turner filed an amended complaint on January 16th, adding the city of Fort Worth as a defendant. Turner brought claims under 42 U.S.C. Section 1983. You hear that a lot. Section 1983 is deprivation of civil rights under color of law. Police acting, depriving someone of their civil rights. So he filed that against all defendants, alleging that they violated his First, Fourth, and 14th Amendment rights. Turner sought compensatory damages, punitive damages, attorney fees and costs, and declaratory judgment that the defendants had violated his constitutional rights. The three officers filed motions to dismiss Turner's submitted complaint. The district court granted the motions to dismiss on the basis of qualified immunity again. The court reasoned that Turner failed to meet his burden of showing that the defendants were not entitled to qualified immunity because he failed to show that their actions violated any of his clearly established statutory or constitutional rights, or that their actions were objectively unreasonable. Turner timely appealed. So just, again, as a matter of how this works its way through the court, on a motion to dismiss, the appeals court reviews it, what we call de novo. So they're not giving any deference to the lower court's decisions below. They're looking at all the facts as they see them there and making their own decision on this. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its facts, to overcome that 12b-6 hurdle. So the analysis of all of this, the legal analysis, is Section 3. To state a claim under 42 U.S.C. Section 1983, a plaintiff must first show a violation of the Constitution or federal law, and then show that the violation was committed by someone acting under color of state law. The doctrine of qualified immunity protects government officials from civil damages liability when their actions could reasonably have been believed to be legal. When a defendant raises a qualified immunity defense, the plaintiff has the burden of establishing the inapplicability of that defense. To meet this burden, the plaintiff must show, 1, that the official violated a statutory or constitutional right, and 2, that the right was clearly established, and that's the key phrase in all of this, at the time of the challenged conduct. Like the district court, we have the discretion to decide which prong of the qualified immunity analysis to address first. Okay, so Section A is First Amendment. The district court concluded that the defendants were entitled to qualified immunity on Turner's First Amendment claim because he failed to demonstrate that the defendant's actions violated a clearly established right or that their actions were objectively unreasonable. In particular, the district court ruled that a First Amendment right to video record police activity was not clearly established. The district court's analysis rested on the second clearly established prong, so we begin there. So Section 1, whether the right was clearly established in September 2015. For a right to be clearly established, the contours of the right must be sufficiently clear that a reasonable official would understand that what he is doing violates that right. Thus, the right must already be clearly established at the time of the challenged conduct. When considering whether a defendant is entitled to qualified immunity, the court must ask whether the law so clearly and unambiguously prohibited his conduct that every reasonable official would understand that what he is doing violates the law. So they go on to say, we must be able to point to controlling authority or a robust consensus of persuasive authority. And that distinction comes up here in a little bit. So where no controlling authority specifically prohibits a defendant's conduct, and when the federal circuit courts are split on the issue, the law cannot be said to be clearly established. This is true even when the circuit split developed after the events in question. As the Supreme Court has explained, if judges disagree on a constitutional question, it is unfair to subject police to money damages for picking the losing side of the controversy. Yeah, and we should note also here that's how things get in front of the Supreme Court. The Supreme Court takes very few cases that are filed with it, but a circuit split, one circuit, the Fifth Circuit says one thing, the Ninth Circuit says something the opposite, and the Supreme Court takes that on one of those two cases and makes a decision that basically resolves that circuit split, picking either the Fifth Circuit's or the Ninth Circuit's position on that, or maybe something in between. But that's how these cases do get in front of the Supreme Court. This one, I as I understand it, never did go further than the Fifth Circuit. So at the time in question, neither the Supreme Court nor this court had determined whether First Amendment protection extends to the recording or filming of police. So they're saying that it wasn't clearly established at that point. The general proposition, for example, that an unreasonable search or seizure violates the Fourth Amendment is of little help in determining whether the violative nature of particular conduct is clearly established. Thus, Turner's reliance on decisions that clarified that First Amendment protections extend to gathering information does not demonstrate whether the specific act at issue here, video recording the police or a police station, was clearly established. The district court stated that circuit courts are split as to whether or not there is a clearly established First Amendment right to record the public activities of police. The circuit courts are not split, however, on whether the right exists. The First and 11th Circuits have held that the First Amendment protects the rights of individuals to videotape police officers performing their duties. In American Civil Liberties Union v. Alvarez, the 7th Circuit explained that the First Amendment protects the audio recording of the police and concluded that an Illinois wiretapping statute, which criminalized the audio recording of police officers, merited heightened First Amendment scrutiny because of its burdens on First Amendment rights. No circuit has held that the First Amendment protection does not extend to the video recording of police activity. Although the several circuit courts have explained that the law in their respective circuits is not clearly established while refraining from determining whether there is a First Amendment right to record the police. We cannot say, however, that existing precedent placed the constitutional question beyond debate when Turner recorded the police station. Neither does it seem that the law so clearly and unambiguously prohibited the officer's conduct that every reasonable official would understand that what he is doing violates the law. In light of the absence of controlling authority and the dearth of even persuasive authority, there was no clearly established First Amendment right to record the police at the time of Turner's activities. And here's your conclusion. All three officers are entitled to qualified immunity on Turner's First Amendment claim. That he had the right to film the police and that was a clearly established right. They're saying that was not clearly established enough. But they go on, this is the interesting part of it, they go on to establish it, essentially. They're now addressing, well, whether is it an established right going forward. And you'll hear some discussion in the dissent about this as well. So Judge Weiner goes on to say, although the right was not clearly established at the time of Turner's activities, whether such a right exists and is protected by the First Amendment presents a separate and distinct question. Because the issue continues to rise in the qualified immunity context, we now proceed to determine it for the future. That First Amendment principles, controlling authority, and persuasive precedent demonstrate that a First Amendment right to record the police does exist, subject only to reasonable time, place, and manner restrictions, which is a phrase you hear a lot in First Amendment analysis and other constitutional analysis. The court goes on to say the First Amendment goes beyond protection of the press and the self-expression of individuals to prohibit government from limiting the stock of information from which members of the public may draw. I won't read the rest of this analysis, but basically they're saying, yeah, maybe in 2015 that wasn't as clear as it should have been. We're making that the rule now. They go on to say, we agree with every circuit that has ruled on this question. Each has concluded that the First Amendment protects the right to record the police. They then say, like all speech, filming the police may be subject to reasonable time, place, and manner restrictions. Things like you can't get up in their face, you can't interfere with their activities. So that's the First Amendment analysis. They've decided, no, it wasn't clear enough for you to pierce the qualified immunity of these police officers, so that dismissal stands. But now we look at the Fourth Amendment issues here, and this has to do with Turner being cuffed and placed in the backseat of the police car. So the court says Turner also insists that he has asserted plausible claims under Section 1983 to which the defendants are not immune, viz, however you pronounce that the officers violated his Fourth Amendment rights to be free from detention, absent reasonable suspicion, and warrantless arrest absent probable cause. So you can detain a person under Terry v. Ohio if there's reasonable, articulable suspicion that crime is afoot, but you have to have probable cause to actually arrest them. And what's a detention versus what's an arrest? And that's what the court gets into here. So with respect to officers Grinalds and Dias, the ones who first approached him and detained him, the court talks about detention. Turner alleges that Grinalds and Dias' initial questioning of him violated his Fourth Amendment right to be free from detention absent reasonable suspicion. The police can stop and briefly detain a person for investigative purposes if the officer has a reasonable suspicion supported by articulable facts that criminal activity may be afoot. That's Terry v. Ohio language. The Supreme Court has said repeatedly that when determining whether officers had reasonable suspicion, courts must look at the totality of the circumstances of each case to see whether the detaining officer has a particularized and objective basis for suspecting legal wrongdoing. Courts consider only the information available to the officers at the time of the decision to stop a person. Even if we assume, arguendo, that Grinalds and Dias violated Turner's Fourth Amendment rights by detaining him without reasonable suspicion, we cannot say that his detention was objectively unreasonable in light of clearly established law. They go on to say the Fourth Amendment is concerned with ensuring that the scope of a given detention is reasonable under the totality of the circumstances. And they further conclude an objectively reasonable person in Grinalds or Dias' position could have suspected that Turner was casing the station for an attack, stalking an officer, or otherwise preparing for criminal activity, and thus could have found Turner's filming of the routine activities of the station sufficiently suspicious to warrant questioning and a brief detention. So detaining him, they said, is reasonable under those circumstances. We cannot say that when viewed in light of the totality of the circumstances, Grinalds and Dias' initial questioning or detention of Turner before he was handcuffed was objectively unreasonable in light of clearly established law. Accordingly, Grinalds and Dias are entitled to qualified immunity on the Fourth Amendment claim here, at least with respect to the detention itself. But then we go to the arrest, which is the actual physical cuffing of Turner and placing him in the back seat of the car. The court says Turner also contends that the officers violated his Fourth Amendment right to be free from unlawful arrest. The parties dispute whether Turner's detention amounted to an arrest. A seizure rises to the level of an arrest only if a reasonable person in the suspect's position would have understood the situation to constitute a restraint on freedom of movement of the degree which the law associates with normal arrest. Goes on to say, when determining whether an investigative stop amounts to an arrest, the relevant inquiry is always one of reasonableness under the circumstances, which must be considered on a case-by-case basis. Using some force on a suspect, pointing a weapon at a suspect, ordering a suspect to lie on the ground, and handcuffing a suspect. there you go, handcuffing, whether singly or in combination, do not automatically convert an investigatory detention into an arrest requiring probable cause. But an investigative detention must be temporary and last no longer than is necessary to effectuate the purpose of the stop. Turner alleges that he was handcuffed and placed in the back of the patrol car where the officers left him for a while, in quotes. And they go on to say, although Turner has not alleged the length of time that he was detained in the backseat of the patrol car, Grinnell's and Dias's actions handcuffing Turner and placing him in the patrol car were disproportionate to any potential threat that Turner posed or to the investigative needs of the officers. They go on to say, we conclude that a reasonable person in Turner's position would have understood the officer's actions to constitute a restraint on Turner's freedom of movement of the degree which the law associates with a formal arrest. So it was the amount of time in the backseat of the car combined with the cuffing that led to the conclusion that this reached the threshold level of an actual formal arrest. They go on to say, based on the allegations of Turner's amended complaint, the officers lacked probable cause to arrest him, and the officers did not dispute this. So for arrest, you have to have probable cause. For detention, you have to have reasonable suspicion, articulable suspicion. They're saying that this rose to the level of arrest, and therefore it required probable cause, and they did not have it. But they go on to say, but the police cannot arrest an individual solely for refusing to provide identification. And certainly under the Texas law, that's as clear as it could be, but also under Fourth Amendment analysis. So we are satisfied that Turner has alleged a violation of his Fourth Amendment right to be free from unlawful arrest. They go on to say, we are satisfied that no objectively reasonable person in these officers' position could have believed that there was a probable cause to arrest Turner under the circumstances alleged in the amended complaint. Grinnell's and Dias are therefore not entitled to qualified immunity at this stage of the litigation on Turner's Fourth Amendment claim that the officers violated his right to be free from warrantless arrest absent probable cause. So they've disposed of Officer Grinnell's and Dias under the First Amendment claim. They're saying, sorry, that was not a well enough established, clearly established right to film the police, so they don't lose their qualified immunity. Under the Fourth Amendment claim for detention, yeah, that was reasonable under the circumstances, so they do not lose their qualified immunity. Under the arrest, yes, that rose to a threshold constituting an arrest. They did not have probable cause. They should have known better. That does cost them their qualified immunity. So then the court moves to Lieutenant Driver, the supervisor who showed up, who fairly quickly seems to have gotten things resolved and gotten Turner sent on his way. But Turner's point is no. He stayed in the back seat for a while. The court says supervisory officials are not liable under Section 1983 for the actions of subordinates on any theory of vicarious liability. So he's not responsible through vicarious liability for sure. So then they take a look at, well, did he personally act reasonably? And they conclude Driver acted objectively reasonably in light of the circumstances, namely by apprising himself of the situation and acting accordingly. He's the one who said, you're right, when Turner said they couldn't arrest him for that. Driver is therefore entitled to qualified immunity on Turner's Fourth Amendment claim. So, kind of ironically, Driver's the one who gets named in the style of the case, but he's out of it pretty quickly here. And so the court's conclusion here is we affirm the district court's grant of qualified immunity to Grinnell's, Dias, and Driver on Turner's First Amendment claim and on his Fourth Amendment claim for unlawful detention. With respect to Turner's Fourth Amendment claim for unlawful arrest, we affirm the district court's grant of qualified immunity as to Driver, but we reverse as to Grinnell's and Dias and remand for further proceedings on that claim. So the court had basically dismissed the case because of qualified immunity. The circuit court is saying, nah, no qualified immunity on that. We're sending it back to you, Judge McBride. Try that part of the case. And so the last part of this is the dissent. So Edith Brown Clement, again, an HW appointee, is dissenting. First, she's saying that, well, I'll give you her words here. I respectfully dissent from the majority's dicta, and dicta just means that it's a statement made by the court that doesn't really address an issue in this case. Like, this case was not about going forward is a First Amendment right to film the police. So all of that discussion by the court is dicta. It's not really relevant to this specific facts in this case. So I respectfully dissent from the majority's dicta purporting to clearly establish a First Amendment right to film the police, and from the majority's reversal of the district court's grant of qualified immunity to officers Grinalds and Dias regarding Turner's unlawful arrest. So she's not buying that this thing is such a firmly established, clearly established rule that you can film the police still. And so she doesn't agree with that. And she's saying that these officers, we'll see what she says in a minute, but that they did not actually arrest Turner. So her point on the first part is that the Supreme Court has repeatedly reversed attempts to define clearly established law at such a high level of generality. And a high level of generality is you can film the police anytime and under any circumstances. She's saying that no, that can't be the clearly established law. You still have to look at all circumstances in the case. And then with respect to the arrest, her point is basically that the police did not hold him for an unreasonable amount of time. So she says, because Turner himself requested a supervisor, a reasonable police officer in that situation could believe that waiting for the supervisor to arrest at the scene did not transform Turner's detention into a de facto arrest. So she does not like establishing a clear rule that you have a right to film the police officers under any circumstances, and she does not believe in piercing the qualified immunity of Grinalds and Dias under the circumstances she felt like they behaved reasonably in that case. So that's not a U.S. Supreme Court case. It's a Fifth Circuit case, but it's an interesting one. It's certainly a relevant case to First Amendment auditors. And again, Batosai is I think a well-known person in that community, and it's an interesting case. The video of the actual arrest and detention is out there. I think on Turner's YouTube page itself, but I think a lot of people, I think, in fact, have covered that case also. So that is out there as well. So that's our case for the week. More to come. If you have thoughts on which ones you'd like to have analyzed, I'm happy to consider that. But that's what I have right now on Turner v. Driver. Hope you appreciate that. Again, always asking for a like and a subscribe and a ring the bell. Hopefully we'll get some discussions going on some of these cases, and we will talk to you guys soon. Thank you.